Recording in progress.
Excuse me, that's me, I think, here. Hold on 1 second while I get out of here. So good morning. This is Erica Berg. I'm sorry for the technical difficulty, but now I at least have saved everybody else if we have any more technical difficulties. I started it off. So good morning. I'm Erica Berg. I am the Vice Chair and incoming Chair of the State Bar Dispute Resolution Section. Really pleased to have all of you join us today for our arbitration forum. This had been a series in person over many years, and now we are sort of rebooting it, reformatting it into two separate sessions. In the morning session, we're going to be focusing on some of arbitration's fundamentals, and in the afternoon, we'll have a more master class for some additional issues. We're going to kick it off, and I'm very grateful to Valerie Sanders for joining us and agreeing to kick this off with her getting into and out of arbitration. Valerie is of counsel at Eversheds Sutherland. She's in the litigation practice group. She has a lot of experience in the international arbitration world and is very familiar with the issues that she's going to be talking about today. We do not have all of the CLE materials to be distributed yet due to the bar's website malfunction, but you will be getting those after that, after the CLE is finally approved. But that has been submitted, and unfortunately, we're just not able to distribute it until we're done. But Valerie has some slides to share with us today, and she will be telling us how to get into and out of arbitration. Thank you so much, Valerie. Really appreciate it.
Oh, it's my pleasure. Thank you, Erica. I really appreciate the invitation, and thanks everybody for joining us this morning. I think it will become clear very quickly that this is not a fundamentals of PowerPoint course. So we'll see what happens. I'm going to try now to share my screen and hopefully not only show you my presentation, but maybe even show it in presentation mode. So that's what I'm seeing. Oh, good. Okay, great. All right. So, okay, happy to kick us off here. And I'm going to kick us off with what I think is basically the message for the whole day, right? Which is that arbitration is a creature of contract. And it seems pretty basic, but this is the thesis that will underlie certainly pretty much everything I'm going to talk about, and I would bet you is going to significantly inform everything you hear all day. And so an initial thought when I say that is, well, but hey, there's a federal statute, right? It's right there in your first slide, the Federal Arbitration Act, the FAA, and Georgia, of course, has an arbitration code. One might say two arbitration codes. More on that in a minute. So, is it really just contract? Well, it's not just contract, but that's where it starts. And the way I view the FAA or the Georgia Arbitration Act is, but in particular the FAA, frankly, for this reason, is it sort of permits the supremacy clause to swoop in and say, hey, these kinds of contracts are sort of recognized, you might even say protected, at the federal level. So you can't come in as a state and say, okay, well, we're not going to have arbitration agreements in Connecticut, for example, right? There's always exceptions, like in the insurance contract, in the insurance context, as those of us in Georgia know. But in general, this is a federal law that says these contracts are sort of being taken out of the usual rule that states control the laws around contracting. And then when you get a state statute like the Georgia Arbitration Code, that's sort of a particular state coming in and saying, hey, we're going to make it a little easier for you here in our state, and put it even at the legislative level that here is how we are going to treat these agreements and the way arbitration is going to work here. So the statutes are important in terms of preserving contractual expectations, is sort of how I would put it, but it absolutely is about the contract itself. And so my slides just got sort of the black letter law quotes on that, right? One from Addicts, which is a very recent case from the 11th Circuit, which I'll talk about in a little more detail in a moment. And Concepcion, a Supreme Court case back in 2011, that was a little bit of a, I wouldn't say seismic shift, but absolutely reinforced the notion that these contracts are protected at the federal level. And then we see that the Georgia courts have also said more than once that this is a matter of contract. So let me talk about Concepcion a little bit in this context. AT&T Mobility versus Concepcion from the Supreme Court in 2011 had to do with class action waivers in arbitration agreements. And at the time, perhaps still, under California law, you could not have, it was deemed unconscionable to contractually waive your quote right to bring a class action. So that case went all the way up to the Supreme Court, who said essentially, hey, you can have a class action waiver in a contract if it's clearly stated and both parties agree to it. And from this case comes this statement: courts must place arbitration agreements on an equal footing with other contracts. So that equal footing language, I think that principle will run through, as I said, a lot of what I talk about today, and also what you hear from others today. You can't sort of single out, you being a state generally or a court, can't sort of single out an arbitration agreement and say, hey, normally this kind of provision is okay, but not here. That's not going to be permitted either in favor of arbitration or, as we have very recently seen from the Supreme Court, in a way that is deemed to be overly helpful to arbitration. It's supposed to be like everything else when it comes to the application of contract law. So that's what we're going to see as we work through the slides. And the way I've arranged it is sort of, I'll go back to that in a minute, but I've arranged it in sort of a who, when, how, where sort of scenario about how to get into, or in some cases, as Erica mentioned, out of arbitration. Before I go back to the mechanics, which is really what this slide is about, I want to sort of expound on the creature of contract point and speak to those who, and I'm not in the room with you and I have a list of names, but I don't have a great feeling as to how many of our audience would be in the position of drafting an arbitration agreement in the first instance. And we say drafting, there are a lot of sample clauses out there. So it's not, of course you're drafting it, but it's not so much that you have to craft these clauses from scratch, because they're available and out there from the various arbitration providers and other resources. The big question, particularly in the business to business context, is, do you want one? Now, I don't want to sort of encroach on the folks talking later about international arbitration, but I'll just say for this morning's purposes, international has its own kind of special answer. That answer, by the way, spoiler alert, is yes. But in the international context, you pretty much always want arbitration just for enforceability issues. In the domestic business to business context, maybe. And so when my transactional colleagues come to me and say, sort of, do I want an arbitration provision? I know that I can go to these websites and get some quote good ones, but do I want one? And my answer to that is, you've got to look into your crystal ball and play the odds like anything else that we do in a forward-looking capacity. Think about the deal, think about the claims that you think are most likely to arise, and then think about, do you have reasons for preferring from your side of it, arbitration or litigation? And I'll say I'm a huge fan of arbitration in general. Pretty much my main takeaway from this 6-week defamation trial that just happened in Virginia was, wow, think of all the other things, the judge or the jurors could have been doing during those six and the clerks and everybody and the marshals during those 6 weeks. I mean, and folks have a jury trial right. I don't mean to diminish that. It's completely appropriate that somebody exercise it, but there's a lot going on in courts. And to the extent we've got former retired judges in our audience, they know that better than any of us. And I think that Sometimes we as civil practitioners forget how very much is going on in court. So I'm a huge believer in arbitration. I think it's great for business disputes, which is what I do. So I don't mean to diminish that when I say at the outset of the deal, think about what is going to be probably best for your client, right? Are you likely to want publicity and public filings? Then that would tend to think maybe you don't want to arbitrate. Is the cost of arbitration likely to be a particular issue for your client as opposed to the counterparty? That might be another downside. And obviously the flip of those would go in the other direction. So the part of a corollary, an important corollary to arbitrations being a creature of contract is think about whether you want it when you're doing a deal agreement or any kind of pre-dispute arbitration agreement, because you should expect, this isn't earth-shattering, you should expect the party's clear written agreement to be enforced. So while out of is in the title here, and there are some ways that some folks are going to not have to arbitrate, basically because they didn't agree to it in the specific instance, but expect the contract to be enforced, and think about that when you're working with your client at the front end about what sort of agreement your client would most like to enter into. I mean, there's leverage and maybe you get what you want, maybe you don't, but think about that at the front end.
Hey, Valerie, it's Erica, and to all others who are watching as well, please do ask questions. I'll be monitoring the Q&A, but I had a question for you on this, advising folks on arbitration. Do you tell them what the enforcement mechanism is if there's an award? Because that's one thing that I think a lot of people aren't really familiar with.
Yeah, thank you, Erica. Yeah, that's a huge consideration. And I don't know whether you'll hear more about it later in the day, but as Erica says, it's very relevant at the front end. There is, generally speaking, there is not a traditional appeal right in arbitration. This is where, and I could talk to you all day about the AAA, for example, does have some optional provisions for sort of an arbitration appeal where you might go to a second panel. So I don't want to speak in absolutes, but in court, if you get an arbitration award or your opponent does, the grounds on which a court will set that award aside are limited. One might say extremely limited as compared with a traditional appeal. And generally speaking, and this, maybe you'll hear more about this later today, generally speaking, a court asked to set aside an award is going to look at notice, fundamental fairness, was one of the arbitrators sort of not neutral in a way that wasn't, or potentially not neutral in a way that wasn't sufficiently disclosed. They're going to look at process issues. What a court generally is not going to do when asked to enforce or set aside an arbitration agreement is put itself in the seat of the arbitrator or the arbitration panel and say, do I think they got it right? Even under like an abuse of discretion standard. That is not to be expected in arbitration. So Erica's absolutely right that when you're advising a client about what do they want, that's a huge consideration. When you think about the disputes that are likely to crop up, is your client likely to be in the side of thinking, yeah, that's fine. I'm going to trust the arbitrators that are chosen as prescribed by our agreement or any rules incorporated in our agreement. And I will understand that the chances of a court setting that aside are much less than it would be if, generally speaking, again, much less than it would be if we had gone to a trial court and then went through the appellate process following that. So that's another thing to think about. And this actually is a good segue into this slide about the provisions for domestic or international arbitration. Arbitration is, as I said, a creature of contract, but there are statutes around how those contracts will be implemented and enforced. And this is a little bit, well, it's not really outside my topic, but I just don't have time to cover it all. But the various provisions of federal and state law have specific provisions around filing a motion to compel arbitration or a petition. If you're not already in litigation, you can file a petition to compel arbitration to essentially force specific performance, is what it amounts to, of the party's arbitration agreement. And the sort of practice pointer note here is there's the FAA chapters 1, 2, and 3. So hopefully I'll get this right. The first one is sort of the domestic, and 2 and 3 enact various treaties, which may come into play in international scenarios. Similarly, in Georgia law, you've got the Georgia Arbitration Code and the Georgia International Commercial Arbitration Code, one domestic, one international within that commercial sphere. And one thing I love to say to junior associates is, even though you're doing everything on the computer, you want to look at how the code is organized and look at the title, and then look at the chapters and orient yourself that way. And this is important in the arbitration context as well. And this, I've seen this happen in cases that have gone all the way to Georgia's highest court, where maybe the parties should have been talking about the international part of the federal or Georgia code, and were not, and just nobody had. They had looked at the same old FAA they use in their domestic cases, or that part of the Georgia Arbitration Code that they use in domestic cases, and maybe kind of missed some opportunities by not looking at the whole thing. So another part of this message of sort of walk through the chapters at the front end is look at the provisions for either confirming or setting aside arbitration awards. And you're probably going to be under the FAA unless you're specifically choosing the Georgia Arbitration Code, which is another thing you want to think about. But at the front end, go ahead and look at, okay, if I get an award at the end of the day, or the other side does, what are going to be the grounds to have it either confirmed or set aside? Because as Erica says, that is very much a front end consideration. So, I was going to talk about, I did talk about Concepcion. Okay, well, let's talk about who is or can be bound by an arbitration agreement. And this goes to the issue essentially of sort of non-signatories. So signatories are pretty obvious, right? If you or your client signs an arbitration agreement or accepts an agreement by conduct, you know, sometimes particularly in maybe the employment or consumer sphere, it may be a question of, you know, by accepting this offer of employment, you agree, or by clicking here, you agree. And so think about electronic signatures and acceptance by conduct as well. But signatories, meaning kind of the named parties, should expect, again, nothing really new here from Contracts 101. If you have accepted an offer, and part of the terms of that offer are that we're going to arbitrate disputes within a stated scope, you should expect to be bound by that. Again, you know, there may be arguments about that, but that should be your general expectation. The sort of who is bound question becomes a little more interesting in the case of non-signatories. So these are folks who are not named parties, let's say, or not signatories to the initial contract that includes the arbitration agreement. And this comes up all the time, right? I mean, if you're suing about a car that you bought, maybe you have a contract with the dealer, but you're also suing the finance company. If you have an employment dispute, maybe you have an employment contract or a handbook or some other arbitration agreement with the entity that employs you, but maybe your manager is also a named defendant. Maybe if it's a business breakup, you're suing the business entity, but also your partner or soon to be former partner. You know, and I could go on, right? Trade secrets, there's all kinds of situations in which one entity may be the one who, one defendant may be the one who signed the arbitration agreement, but there may be additional defendants, people, individuals frequently, but also maybe sister companies or related companies, particularly if you think there's been some kind of conspiracy or money changing hands among parties in a way that you object to. There's often, and I'm, you know, not a plaintiff's lawyer, generally speaking, but, you know, when you're suing a number of folks, you may have all kinds of different parties on that other side of the V. So what happens when you've got an arbitration agreement with one of them or fewer than all of them? Okay, so what happens then really depends. I mean, that's our favorite answer. the big principle at play here is equitable estoppel. And the case is sort of, so this should be sort of the first thing you're looking at, right? And I view these presentations as kind of issue spotting exercises. If you've got this situation, either you're thinking as a plaintiff's lawyer of suing multiple entities, or you're a defendant in a case where there's an arbitration agreement in play, you want to think about what the arguments are for and against bringing everything to arbitration, even perhaps claims against or by non-signatories. One of the first things you should be looking at is this notion of equitable estoppel. That's how this is frequently framed in the federal and Georgia cases. And the cases tend to talk about two different species of this. One being reliance on the contract. If your client as a plaintiff is relying on a contract to assert a claim against a third party, and that contract includes an arbitration agreement, it's going to be harder for you to say, okay, but this third party, this, individual, I'm suing my employer and my manager, and the manager didn't sign the arbitration agreement. Only the employer did. So I can go to court with the manager. If your claims all rely, or even if a significant number of them, as a plaintiff rely on the contract, if your claim is essentially my employment agreement entitled me to XYZ, then you're going to have a hard time disclaiming the arbitration agreement within that contract. And again, it really is basic contract law, right? Generally speaking, you don't get to pick and choose, oh, I'm suing on this part of the contract, but I don't want you to enforce this other part of the contract, right? So it's simple first principles, but you're going to see it in the cases in this context talking about equitable estoppel in the form of reliance on the contract. The cases also talk about, the cases in this area also talk about substantially interdependent and concerted misconduct among signatories and non-signatories. And this comes up, and we're fully now into the territory where it's becoming hard for me to see the difference between these things. But they do get called two different things. So issue spotting wise, you should be aware of it. This interdependent and concerted misconduct is a situation where the plaintiff, again, has framed their allegations in terms of interdependent or concerted misconduct. My manager and my employer conspired to do XYZ, or the president of the company and the company together defrauded me of my interest in the company, just as some examples. So again, but that's equitable estoppel again, right? It's you as a plaintiff. If you're going to say that this person with whom I have an arbitration agreement worked in concert with another defendant to do something bad to me, even if that thing is a tort maybe and not a breach of contract claim, if you've got an arbitration agreement with one of those defendants, there's a good chance you're going to have to arbitrate those claims against all of the defendants, including the non-signatories. This is, again, if the non-signatories want you to do that, right? I mean, the factual situations I've been talking about are situations where a plaintiff sues in court, there are multiple defendants, one of them has an arbitration agreement with the plaintiff, and all of the defendants want to be in arbitration. And so this is a situation where, to put it in the sort of terms one sees in the cases, where the non-signatory wishes to compel arbitration. It is more difficult to force a non-signatory to arbitrate. And that sort of makes sense too, right? Because in the first situation, the plaintiff has signed an arbitration agreement. And the argument would be, has signed an arbitration agreement that covers the disputed issue here. And sure, there are some additional defendants, but the claims are all meshed together and or dependent on the contract, and these other defendants all want to be in arbitration. I would expect in that situation to go to arbitration. A little different if you've got a defendant who says, no, I'm entitled to a jury and I never agreed to arbitrate and I want my trial by jury. That's a little bit different if you're in a situation where the defendant does not want to arbitrate. So keep that in mind as you're looking at these issues, if and when they arise. I've put agency and third party beneficiary in parentheses because, analytically, those are not that distinct from the overall notion of equitable estoppel, right? I mean, if I'm a third-party beneficiary under a contract that includes an arbitration agreement, and I'm suing some folks saying, hey, I didn't get the benefit of that I was supposed to have under this contract. I mean, it seems to me a species of equitable estoppel for those defendants to say, if they wish to, well, the contract under which you're claiming a benefit has an arbitration agreement. And again, first principles, you can't say, please court enforce this part of a contract and not this part. So you will sometimes see in the cases notions of agency and third-party beneficiaries in this sort of non-signatory arena. But again, for issue spotting and sort of just basic analysis purposes, it's largely about equitable estoppel. Or is someone trying to have it both ways? Are they trying to get only part of a contract enforced? Those are the considerations that are going to crop up here. So these are all issues to be looked at if, again, you as a plaintiff's lawyer are contemplating a claim where there's one of these agreements in play. You can sort of advise your client how this is likely to play out. And then if you find yourself on the other side of it, if you're a defendant either with an arbitration agreement or maybe without one, but you read the complaint and you say, okay, but the claims against me seem to have a lot to do with this written agreement, get a copy of it, even if you didn't sign it, and see if it has an arbitration agreement. Because as we will see in a couple of slides, you've got to jump on the arbitration right if you want to exercise it. Because again, basic contract principles, waiver of a right is going to mean losing it. So this business of, is there an arbitration agreement in play and does it cover all the claims, needs to be thought about early on. Okay, so I do have a slide on mechanics, a little bit of a foray into mechanics, right? How is the agreement enforced? So you've got an arbitration agreement. And so what do you do? So what do you do if you get sued? You know, I have an arbitration agreement with, say, my former business or my business partner, and my business partner all of a sudden sues me in court. What do I do? Well, assuming I wish to compel arbitration, again, I can waive that right if that's my decision and I want to see that through. But if I wish to enforce the arbitration agreement, I am going to file in the case in which I have been sued, I, as the defendant, am going to file a petition or motion, actually, if there's pending litigation, to compel arbitration. So this slide probably should say petition or motion to compel arbitration. These are the sites. This is the domestic site in the Federal Arbitration Act, and then also, I believe, the domestic site under Georgia law, the mechanism by which you can file a petition to compel arbitration. So if you've got an existing case, you're going to file a motion. You're going to say, hey, court, I've been sued, but we have an arbitration agreement, and you're going to attach it, and it's going to be authenticated, and you're going to say, please compel arbitration. If you are sued, say, in state court, and you want to file a petition to compel arbitration in federal court, you can also do that, but there needs to be federal jurisdiction. So this is, I don't actually know how to highlight. I might know how to highlight. Do I? Let's see. Yeah, that not really. I just crossed it out. But the fact that the FAA does not confer subject matter jurisdiction in federal court is something that I find even seasoned lawyers who don't practice regularly in the area sort of not thinking about. I mean, if they thought about it, I think they'd get it right, but it doesn't crop up as an issue because, you know, it's a federal act about arbitration. And so that in federal, we know there's a liberal federal policy in favor of arbitration. And so it sounds like the kind of thing that you can just bring to federal court no matter what. That is not the case. So don't put in a pleading or a complaint or petition that, you know, subject matter jurisdiction is conferred by the FAA. It's not. This is in the domestic arena. International is different, and they'll talk about it, although international is likely to have diversity jurisdiction just about always anyway. So that's its own, you could split hairs, I think, about which statutes are actually providing jurisdiction in federal court in the international sphere, but in the domestic sphere, which is, you know, what all of us are going to be mostly doing, the FAA does not confer subject matter jurisdiction. So what do? What do you cite for your jurisdictional basis? Well, the same thing you always do. And you'll see this referred to as look-through, federal look-through jurisdiction for motions to compel arbitration, meaning the statute, actually, I should have it in front of me, but it says you can bring the motion or the petition in the federal court, which, but for the agreement to arbitrate, would have subject matter jurisdiction, right? Or so you do your usual diversity pleading or federal question. If the underlying dispute is about the validity of a patent, then I say we've got a federal question, and so that gets us into federal court, and because we're looking through to the underlying dispute, and we've got an arbitration agreement, so federal court, which I'm properly in, please order arbitration. Similarly, if you've got diversity, if you've got, you know, complete diversity and $75,000 plus in controversy, that's what you plead as your jurisdictional basis in federal court. And then you say, now that we're here, we're within your jurisdiction, please enforce our arbitration agreement. So again, that's something that comes up a whole lot, especially since it's been sort of an issue on folks' minds lately, because just this year, looking at my little note at the bottom with the star, so Badgerow is a Supreme Court case that came out, I don't know, maybe a month ago, which talks about motions to confirm or vacate arbitration awards, right? So getting into this again is a little bit out of my topic, but it's interesting and it's kind of related to look through jurisdiction, so I want to mention it. When you are moving to compel arbitration in federal court, it's the look through jurisdiction is what you need. You say, okay, forget the arbitration issues for a moment. Do I have a federal question? Do I have diversity jurisdiction? Then you get into federal court on one of those bases and you seek enforcement of the arbitration agreement. That's not what happens at the end of the day when somebody's got an arbitration award. When you've got an arbitration award that says, you know, okay, you, Valerie Sanders, have been awarded $1 million by the arbitrators. If I want to go to court and confirm that award, haven't made an order of the court, or if my opponent wants to go to federal court and say, hey, this should be vacated. I, you know, didn't get notice of the hearing. I wasn't invited. This is crazy. If either of us wants to do that, we've got to say there is no more look through jurisdiction. So in that case, if my opponent and I are non-diverse, well, we've got $1 million dispute, but we don't have diversity of citizenship. So that's not going to be a basis for federal jurisdiction. Similarly, if our underlying dispute was about the validity of a patent, say, that's not going to be a way to get into federal court for a motion to confirm or vacate. At that point, and I suggest everyone take a look at Badgerow, it's a pretty short opinion, but at that point, you're dealing with, you know, an arbitration award is sort of the dispute. It's almost like a merger clause. I mean, the underlying dispute doesn't matter anymore. It's just the dispute between you about the enforceability of this, in my example, $1 million award. So again, at the front end, you're going to plead jurisdiction the usual way. FAA is not your jurisdictional basis. At the back end, you still have to plead jurisdiction the usual way, but you don't have that look through. You don't get to look through to what the underlying argument was about. It's just the dispute about the arbitration agreement itself at that point. In the middle, which I kind of skipped over, there are provisions in both the federal and state act to stay the pending action where the issue is referable to arbitration, right? So generally speaking, if there is a pending action, if you're in the situation where you have been sued in court and are bringing a motion in that action to say, hey, court, we've got an arbitration agreement, please compel arbitration of this. There's statutory authorization for you to combine that with a request to stay. In the Georgia statute, it's the same section. It's two different sections in the domestic portion of the FAA, but you're going to say, please compel arbitration and stay proceedings. And that does a couple of things. Number one, a stay is not going to be a final appealable judgment. And so, you know, the case sort of stays, if not administratively open, at least alive. And then after you've had your arbitration, you've got your open action into which you can bring your award to be confirmed, or if you are dissatisfied with the award and think you've got grounds to have it vacated or set aside, you can go back into the pending action and do that. So again, you want to look through the relevant portion of the federal or Georgia statute, but broadly speaking, the process is going to be to file a motion or petition to compel arbitration with a standalone, with its own jurisdictional basis. You're going to ask the court if there's a pending action. If you're filing a motion and a pending action, you're going to say, please stay this case while we go and have our arbitration, and, you know, sort of to be continued, for those who watched a lot of TV in the 70s, as I did. So maybe they still do that. I don't know. All right, next, I don't know why my slide does not want to advance. Oh, because I'm still on annotate mode. Hang on. Okay, no, it's going to just stick there. Great. When should the agreement be enforced? Okay, this is the waiver. This is the waiver. I'm going to try to use my eraser. Oh, yay. Okay, so this is the waiver issue that I just mentioned a moment ago. This is pretty huge. This, as you can see, this case from the Supreme Court, Morgan versus Sundance, just came out, you know, less than a month ago. So I think we're all familiar. Anybody who has encountered arbitration agreements probably has gone through this thing, this sort of, if you're trying to enforce an arbitration agreement, you've probably gone through that sort of fear of waiver moment, right? Like, if I answer, am I waiving it? Well, what if or arguably waiving it? What if I answer and I say, oh, I'm answering, but I'm reserving my right to arbitrate? Or what if I file a motion to dismiss because maybe I have a good 12b6, but then I still want to sort of save for later, you know, there should be if this were pop-up video to continue my TV analogies. If you find yourself thinking, maybe I'll save my right to arbitrate for later if this doesn't work. Yeah, that's a bad idea. That's the kind of thing that is unlikely to work, broadly speaking. But I think we've all thought about that, right? When you're, certainly if you're a defendant's lawyer, when you get sued and you have an arbitration agreement that you maybe can rely on, you sit down with your client and you say, we've got this, do we want to enforce it? And until May 23rd, there was some wiggle room there, certainly in most, if not all, circuits. And you could maybe litigate for a little while, nobody ever liked, it was never really okay to sort of try your 12b6 and then try your arbitration later if it didn't work. But there used to be more flexibility around, well, I'm not sure about the non-signatories, I want to talk with them, so let's answer and kind of figure out where we are. Because it used to be in many, if not all circuits, that the waiver question would include an element of prejudice to the other party, right? So used to be, and this is all before Morgan versus Sundance, which is why it's kind of a big deal, used to be that you would sort of, if clearly a 12b6 that didn't work, followed then by a motion to compel arbitration, was always going to be problematic, right? Because I, as the plaintiff's lawyer, am going to say, no, you made me respond to and defeat this motion. And then when you didn't get what you wanted in court, only then did you want to arbitrate. And that's always been a good argument, right? So if you're making a plaintiff respond to motions and sort of forum shopping is what it amounts to, that's always been problematic. But what if you just like didn't realize that there was an arbitration agreement? That maybe it was on a separate sheet, or maybe your client is a non-signatory and you didn't realize right away that there was an arbitration agreement that you could rely on. It used to be in those cases that if no prejudice to the plaintiff, okay, you've answered, maybe you've even counterclaimed and they filed an answer, maybe you served a little bit of discovery. But if that hadn't gone on too long, you used to have a decent chance to still be able to enforce your arbitration right later. That is going to be much more difficult, if not impossible, but I'll just go with more difficult after Morgan versus Sundance. Because this was a case, in this case, and again, it's a short opinion by Justice Kagan, and I recommend you read it. That rule that we looked at on slide 1 about arbitration agreements should be on the same footing as other contracts. So that got applied here in a way that, arguably limited the scope of it. It ended up, I guess I would say, contracting the arbitration right, arguably, right? Because what this case says was, normally when we talk about waiver, we talk about known relinquishment of a right or voluntary relinquishment of a known right. We don't usually talk about prejudice to the other party, right? I mean, think about waiving jury, waiving a right to trial in the criminal context, or waiving your right to insist on a certain remedy or whatever. You don't normally go through a prejudice analysis. And so the court said, we do have that rule about arbitration agreements being on the same footing as everything else. We're going to apply that here and say, you don't get to apply this prejudice requirement only in the arbitration context either. So this is also issue spotting wise. If you are researching this issue and you're finding these Court of Appeals cases saying, okay, you got to show prejudice, not so much anymore. It's sort of a new ball game on the waiver field. And my advice to a client always would be, for a variety of reasons, listen, make this decision early. You can't, gamesmanship is not going to work. Decide where you want to be, assert it as soon as you can, and then you won't have to worry about waiver. And that should be the advice, in my view. But to the extent you find yourself having to research whether or not there has been a waiver, this recent case should be your starting point. Okay. So what is to be arbitrated? What is the scope of the arbitration agreement? Let me get one more sip of water. I'm going to sort of take this in two parts. One having to do with the sort of arbitrating arbitrability, and then sort of a broader issue of the scope of the clause. So arbitrating arbitrability, right? So this is the question of, well, my opponent and I have a dispute. I've sued them in court. They've brought a motion to compel arbitration. And I say, okay, there's an arbitration agreement between us, but you court shouldn't apply it. So then the next question is, does the court decide that challenge, or does the arbitrator or arbitration panel decide that challenge? So the first question you need to ask yourself is there a so-called delegation provision? And that's what the cases call it. And this is referring here to a provision in the arbitration agreement that says the arbitrator is going to decide all issues, including arbitrability, or it might say including whether a particular dispute should be arbitrated, language like that. Is there something that explicitly it says in the arbitration agreement that this kind of threshold dispute is going to be decided by the arbitrator? Again, a so-called delegation provision. So that's the first thing you look for. The next thing you look for, because, right, if I'm the plaintiff here, I may say, okay, yeah, but my whole point is we shouldn't be in arbitration. So why this whole agreement shouldn't be enforced, and therefore the arbitrator shouldn't be deciding anything, much less, whether he or she should be going any farther. So then the question becomes, is there a challenge by the plaintiff specific to the arbitration agreement? Or you might think of it as specific to the arbitration provision in a larger agreement. just this idea that, okay, my dispute isn't arbitrable because it's, you know, for instance, this addicts case, which is a recent one. Oh, Supra, that's why it's not the site, but it is recent. It's in the past couple of months from the 11th Circuit. The issue there was that the plaintiff said, you know, under a provision, yeah, I have an arbitration agreement, but under a provision of the Dodd-Frank Act, my claim is not subject to arbitration. So there was a delegation provision in the arbitration agreement, and the 11th Circuit goes through this whole analysis and says, is there a challenge specific to the arbitration agreement? And the argument that the plaintiff was making there, which was this kind of claim can't be arbitrated under Dodd-Frank, and that's not specific to the arbitration agreement. And so in addicts, the dispute was sent to arbitration in accordance with the agreement, which again had a delegation provision. And the first thing for the arbitrator to decide will be, what do I think about this argument that Dodd-Frank says this dispute can't be arbitrated? And if the arbitrator thinks, yeah, the plaintiff's right about that, maybe they end up back in court. But that's going to be for the arbitrator to decide. So this prompts a question, naturally, I think. What might a challenge specific to the arbitration agreement look like? Right? Because when you think of the various arguments people have about why something shouldn't go to arbitration, you know, you think about things like, okay, it's not to be arbitrated as a matter of insurance law or some other federal law, or it's not within the scope, you know, that I agreed to arbitrate everything having to do with my employment, perhaps, but now I'm suing as an owner of the business, not as an employee. Those are not challenges specific to the arbitration provision. An example of a challenge that is, and the court actually mentions this in addicts, the 11th Circuit refers to its prior decision in the Parm case, P-A-R-M, and the argument there was that the arbitration provision specifically said that the parties were going to arbitrate before, and I can't remember, it was kind of it was a tribal council or an indigenous bureau or group that turned out not to exist, right? So within the arbitration agreement, it said, you know, we're going to arbitrate it before the, you know, Valerie Sanders arbitration court, and there's no such thing. So Addicts said, you know, in Parm, there really was that specific to the arbitration provision challenge, and that's different. In that case, the delegation provision doesn't apply if the challenge is found to have merit, as in Parm it was. But if you're just saying this dispute isn't arbitrable and you don't have something specific to the arbitration provision that's an issue, you should expect, again, that delegation provision to be enforced. And that goes back to my first slide, right? And sort of the drumbeat that I've sounded throughout, which is that's contract law. I mean, if I've agreed that all issues, including whether a specific dispute, all disputes between me and, you know, my ex-business partner are going to be decided by arbitration, including whether or not a particular dispute is subject to arbitration. If I've agreed to that, it makes sense that it would be enforceable. And then it makes sense though too, right, that if I say, hey, wait a minute, that arbitration agreement, for example, was tacked on to the agreement after I signed it, then things might be different. But in general, expect a delegation provision to be enforced. And so pay attention to that language in your arbitration provision at the front end. One more note there, I don't have the specific 11th Circuit site, but the 11th Circuit has held that if the parties incorporate into their arbitration provision rules of an arbitration provider, and in that case, it was the AAA's commercial rules, I believe, and those rules, at the time you incorporate them, provide that an arbitrator will decide arbitrability, then by incorporating those rules, you have put into your agreement a delegation provision, which again, you should expect will be enforced. So the sort of practice pointer there is when you're kind of going merrily along with a provision you've used before or one of your colleagues has, and it says, we're incorporating the XYZ rules, sounds obvious, but take a look at those rules. Not only for things like what's it going to cost, and is it going to default to 3 arbitrators or 1 arbitrator, and not only for those reasons, which are all good ones to look at it before agreeing to that set of rules, but there may be this delegation issue lurking there, and you want to know what you're agreeing to.
Hey, Valerie, we have one question,
Sure.
and I'm not sure how often this comes up. So this is the fact pattern. If a single arbitrator decides arbitrability, can a 3-person panel thereafter overrule the single arbitrator under AAA rules? And I'm trying to think of this scenario in which it would come up, but it would almost be as though you had an arbitrator appointed solely for the arbitrability. And would that then be binding if say the claim exceeded and you now have 3-person panel?
Yeah, and I will confess, I do not have personal experience with the AAA's sort of arbitration appeal rules. So, but I would think it would be a question of that, right? Like if I've agreed to use those rules and I go to court and say, I don't think this dispute is subject to arbitration, and the court says, you've delegated that to an arbitrator. Then and then the arbitrator says, yeah, I think this is within, and I'm going to arbitrate it. I would imagine, and I'm huge warning lights in my brain about talking about things I've never done, but if the AAA rules otherwise to which the parties have agreed, if they've opted in to, we're going to have a 3-panel appeal following our single arbitrator arbitration, I don't know why that couldn't be among the issues that were brought to that panel. But again, I've never done that. So I think that's probably a matter of the AAA rules themselves and the extent to which the parties have agreed to them.
Thank you.
Sure. The other sort of main big sort of subtopic under what is to be arbitrated. So first there's arbitrability, and then there's, okay, but what substantive disputes have the parties agreed to be arbitrated? Are there carve-outs in our provision for specific disputes, and are they mandatory or permissive? I mean, does it say it's not uncommon to encounter carve-outs for injunctive relief? You know, that we're agreeing to arbitrate everything, but we also agree that a party can go to a court for injunctive relief if necessary, thinking of kind of TROs, although, you can get emergency injunctive relief in arbitration as well, generally, but still, this is not an uncommon carve-out. But then is the carve-out, so that might be a permissive one. You can go to court for injunctive relief. There might be a mandatory carve-out that says, the parties agree to arbitrate everything except, for instance, any dispute about the validity of the licensed patent. And that we both agree is going to go to court. So again, pay attention if you're at the dispute stage, pay attention to the specific language of the agreement by which your client is bound. And if you're drafting, think about these issues. This isn't really a drafting session, but it won't surprise you to learn that the conventional wisdom is to be very wary of including particularly mandatory carve-outs, things that say, we're going to arbitrate these things, but not those things. Take the patent validity example I just mentioned. If you've got a license agreement dispute and you've said, well, we're going to arbitrate disputes under this license agreement, except for challenges to the validity of the patent, which will go to court. And then, one party says, well, hey, I think you've overcharged me on this license under the terms of our agreement. I think what I'm doing is outside the scope of the patent. And also, I think the patent is invalid. So you could, in that situation, find yourself with parallel arbitration and litigation, which almost no one ever wants, for obvious reasons, including, it's public, even if part of it's non-public. It's expensive in the sense that arbitration isn't free the way court is, and it's often thought of as being sort of the worst of both worlds. So never say never, but really do think about whether you want to have specific substantive carve-outs to your arbitration provision, because that can be very, very problematic. I don't know why I have this apostrophe, because that's the kind of thing that if someone else did it, it would drive me crazy. It doesn't belong there. But think too about, oh no, it does. Oh, good. Okay. the provisions relationship. Sorry, I corrected myself unnecessarily. Look at the provisions relationship to the larger agreement. So in addition to, did we carve out patent disputes? Did we carve out Title VII claims? In addition to that, take a look at this, the language of, is it all disputes arising out of the agreement? Is it all disputes arising out of or related to the agreement? Lawyers being lawyers, those little differences can really matter. If you've got, say, an employment claim, but also a defamation claim. If I've got an employment agreement and I say you violated my employment agreement and you also libeled me. Okay, arising out of or related to my employment, yeah, that sounds like that's less arguable, right? Arising out of my employment agreement, okay, maybe a little more arguable. Well, what if the agreement says we're going to arbitrate disputes about the terms of my employment? That's sounding yet more arguable. So, you know, look at all of that when you're either trying to get into arbitration or trying to stay out of it and say, hey, this isn't within what we agreed. Because again, it's going to be about what did you agree to? I guess I'm almost out of time, but also on this, what is to be arbitrated, and this gets into a little bit the non-signatory issue, disputes involving additional parties. Where are we going to land with that? This is another interesting 11th Circuit case, pretty recent, where the plaintiff sued a rent-a-car, and there was also like a booking agent. There was a rental car company and a booking agent, and maybe somebody else who was helping to load things, and maybe there's an arbitration agreement with just one party. Where does all that land? Again, related to the signatories and non-signatories. But the language of the provision can also matter, right? Because if I'm a non-signatory being sued, it probably matters to me whether the agreement says I'm going to arbitrate everything having to do with my car rental versus I'm going to arbitrate everything having to do with the amounts charged to me under a car rental agreement. You know, non-signatory may be differently situated if you're sort of the booking agent in that situation. And finally, and this gets us sort of back to where we started with Concepcion, class arbitration is what if I want to have a class action, or what if I, as a defendant, am faced with a class action? Is there a waiver, a specific waiver in the arbitration provision that says I'm not going to have, I agree that I won't bring a class claim either in litigation or arbitration? Is there such a provision? And then is that provision subject to a delegation provision, right? If my client is sued in a class action, maybe I have an arbitration agreement that says there won't be class claims in litigation or arbitration. It may be, and the plaintiff says, okay, court, I don't think that's enforceable for XYZ reasons. The next question is, does the court even decide that? And then we go back to our subset of issues about there being a delegation provision. And this Larson case, another recent one from the 11th Circuit, is a really good rundown of those issues kind of in seriatim. Okay, wow, 10:28, and that's the end of my slides. So that worked out pretty well.
Your timing was great. Do we have any questions? You can either put them in the, I think you can put them in the Q&A. We'll ask them if anyone's got any thoughts. I have one while we wait, which is when you read Morgan v. Sundance, did you get the impression that they were sending it back and suggesting that waiver was not the appropriate analysis? I mean, Justice Kagan used forfeiture over and over and over again in sort of an oddly way in civil context, right?
She did. I mean, I guess I tend to think of it, it comes down to what you call it. I mean, I definitely read it as forfeit is, again, a sort of a known relinquishment. So I didn't so much make a distinction between waiver and forfeiture. But I absolutely know that throughout my career, there have been cases that have turned on this prejudice factor, and that we just can't expect that to happen anymore. The focus is going to be on the person who is now asserting a right and took a while doing it. The focus is not going to be on the other person and how much additional money or time that costs them.
That's great. That's great. So, well, we really appreciate it, Valerie. my video on here. I mean, you've been great and super educational. This is one of my favorite topics, and you do such a great job with it. So thank you so much for
Thank
joining us today. And we're going to turn it over now to Melinda Holliday and Henry Quillian. And so if you guys would turn your cameras on, and for those watching us, you can select speaker view. If you go up to the view, and if you click on the actual person, you should be able to pin their videos so that you would be able to see the speakers consistently throughout. So Melinda has been an arbitrator for 30 years. She's with the AAA and has had a strong interest in dispute resolution since she was in law school. She focuses her practice on commercial arbitration, and she served as a sole arbitrator, co-arbitrator, and on a panel chair in hundreds of disputes. So we're really lucky to have Melinda here. We also have Henry Quillian, and Henry is a partner at Taylor English Duma, and he is a mediator and arbitrator with Bay Mediation and Arbitration Services. He litigates across the country, and he's arbitrated across the country as lead counsel. His primary focus has been in the construction industry, but has done a number of business disputes as well. So we're really lucky to have you as well, Henry. And we appreciate your joining us, and I will turn it over to the two of you.
Good morning. Thank you. We're delighted to be here. So as you heard from Erica, my approach and my lens is primarily as a neutral, specializing in primarily commercial. I serve on the sports dispute panel, the complex litigation panel. I've heard consumer cases. For the AAA, I have great familiarity with AAA rules, and JAMS rules I have less familiarity with, but just know for the purposes of this presentation, there's not a lot of substantive difference between those two sets of rules. And Henry and I are going to be primarily talking about domestic arbitration as opposed to international arbitration. There is an international arbitration session this afternoon, but generally speaking, what we're going to be talking about are the domestic disputes. And Valerie did a stellar job of setting us up for getting to arbitration, so that Henry and I are going to talk about what to expect from your arbitrator once you're in arbitration. And Henry's going to lead us off with the process of selecting arbitrators and what you want to think about once you've gotten through all of the steps that Valerie took us through.
Yes, and thanks, Melinda. Hopefully everybody's hearing me just fine. We did those tests earlier on. It's a pleasure seeing you in person. I think we've spoken on the phone so many times. So Valerie did tell us how to get into arbitration, or out, as the case may be. But the question is, what were you chasing after, and what did you get once you got in? And one of those things that you want to be obviously especially careful about is who is going to be arbitrating your case, and what are the qualities and aspects of that person. And one of the funnier ones that I've come across along the way, and it related to a matter where there was no signature on any contract, but there was arbitration mentioned in a contract that had gone back and forth between the parties, was that they had designated a non-living individual to be their arbitrator. So they fought hard over whether to arbitrate before a dead person. And in fact, the court did order arbitration, but of course that left the parties trying to figure out who is going to be the arbitrator, because as much as we would love to present to dead people, they usually aren't that good at deciding things. So then you have to figure out, all right, if you're gonna start from the beginning, how are you going to decide who you want to be your arbitrator? Well, as mentioned, that could be designated in an agreement from the get-go, but you better make sure that the people that you're designating are people that are likely to be around if you have a dispute. In a lot of construction contracts, individuals are actually selected at the beginning of a project to serve. And of course, they're asked whether they will serve as effectively arbitrators. It could be a dispute resolution board, could be a person that's employed to come in and resolve change orders on a very expedited basis, effectively in an arbitration. Or you could set up a scenario where you designate the qualities of the persons that you would like to have as potential arbitrators, such as subject matter expertise, a certain number of years in the industry is likely to be involved with the disputes, the people that are certain qualifications from the standpoint former federal judge, if you want to go way up there on the scale, or somebody who's already been a superior court judge, or somebody like Melinda who's spent 30 plus years arbitrating cases, somebody who has very intense familiarity with the processes and also the subject matters of the arbitration. You need to think about what your personal relationships are with these people if you are in the process of selecting them, either by, there are multiple ways to do it depending on what rules are involved. If it's the AAA, very often the first of all is the determination of the size of the arbitration as far as the dollar amount, and that can drive how many arbitrators there are, 1 or 3. Regardless of whether there's 1 or 3, if you put in the subject matter of the arbitration, the AAA will send you a list of people and a bunch of resumes. Well, those resumes are only as good as they are as far as helping you figure out who the people are, unless you have some resource to go to talk to people, look at qualifications and recommendations that have been made regarding the arbitrators. You can talk to colleagues, reach out of your law firm, talk to colleagues, try not to give rise to conflict by doing that. And also think back through your litigation career. Have you had a very adversarial relationship somewhere along the way with one of these arbitrators that's listed? And how is that going to impact the way that arbitrator views you? So in that instance, you often strike people off the list, and then the AAA will select the remaining acceptable arbitrators that the 2 parties have not stricken. Or you could ask for an entirely different list if you don't like anybody that's on the panel. Another way that's done, and it's often set up in the arbitration agreement itself, it will say each party will choose an arbitrator as either a neutral or a quote party arbitrator, and then that the 2 arbitrators that are selected that way will select a 3rd person to be the 3rd panelist. So there are quite a number of different ways you can end up with a person as your arbitrator or a panel of people. So one thing you need to think about is, how long is this arbitration going to be? Is it a 1 day, a 2 hour, a 6 week arbitration? You would want to select arbitrators that you believe have the mental capacity and the overall ability to sustain whatever you're going to put them through as arbitrators. And I hate to say it, but that sometimes is affected by the age of the person. If you think the person's extremely qualified and it's a 1 day arbitration, that's a whole different thing from having 6 straight weeks of 8 hours a day in arbitration. Similarly, if somebody is totally devoted to being a neutral, that might be a very nice qualification for a long arbitration, whereas somebody's a litigator and has a big group of cases they have to deal with, they're not likely to be able to set aside an extreme long period of time. And hopefully, as Melinda will point out, hopefully the arbitrators self-assess whether they should take on this project or not. Because I'm sure that if they're making big money off of it, they would love to do a nice arbitration with lots of parties and lots of time. But they, of course, need to determine on their own whether they are capable of actually professionally doing the job. So that sort of gives you an idea, but essentially, you don't want people who don't want to arbitrate for you to be an arbitrator for you. And you don't want people that won't take great interest in your case to be an arbitrator. And you would prefer to have people that are subject matter qualified to do that. Melinda's going to go into the internal aspects of arbitration and what arbitrators should think about with respect to their own ability to impartially decide an arbitration.
Thanks, Henry. I wanted to say, piggyback on two things that Henry brought up in terms of selecting an arbitrator. And one thing he talked about was party-appointed arbitrators. And it's very important for you as an advocate, and certainly you as an arbitrator, to have a clear understanding of whether or not the party-appointed arbitrator is going to be neutral or non-neutral. Oftentimes you look to the arbitration clause and it will specify that. But if it doesn't, you need to have a clear understanding, both as the advocate and as the arbitrator, because obviously there are enormous differences in whether the arbitrator appointed by the party is serving as neutral or non-neutral. It is fair to say, I think, that non-neutral party-appointed arbitrators are becoming less and less favored. And in general terms, it is more likely that the parties will have provided for neutral party appointed. So I have been, for example, chair of a panel in which both of the party appointed arbitrators, my wing arbitrators, were non-neutral, and then they selected me. What that means in practical terms is that you have two sets of advocates. You have counsel representing the parties, and you have your wing arbitrators, each whose stated mission is to help convince you to decide the case in favor of the party that appointed them. That, in my opinion, is not particularly cost effective. And it also makes for interesting panel dynamics. And we're going to talk about panel dynamics later in this presentation, but that's an important distinction to know. I have also been appointed by parties to serve as neutral party representatives. And that's happened to me in which I don't even have, a strong relationship with the party. So it's not like I know why they chose me and I don't have a strong allegiance to them. But in that instance, you make it very clear from the outset that you are serving as a neutral. So on the panel, you would not be functioning as an advocate for the party that appointed you, and you would certainly not be having ex parte communications with the party that appointed you. In general, what happens in those instances is the party might get in touch with you and say, could you take on this case? And you do a conflicts check at that point, and then they would appoint you, and you would then work with the other party, if there are two parties to the disputes, party appointed arbitrator, and the two of you would select the chair of the panel, and all three of you would serve as neutrals. That also gets into a little bit of what Henry alluded to, which is one big advantage of arbitration is that you choose the decision maker. You have to pay them. There is a cost to that, as opposed to going through the court system, where obviously you're not going to pay the judge, and you obviously are not going to pay the arbitrators directly. And that's a very important barrier, that all fee discussion, payment discussion goes through the administrator, in my case, the AAA. But it's important to know that when you are choosing an arbitrator, you're choosing someone, A, who has subject matter expertise, B, who has some of the considerations that Henry talked about in terms of what's their reputation, what's their knowledge of your reputation. And C, you know that someone who has agreed to accept the appointment has committed to you, the parties, that they have the time and are going to give this the attention that the case deserves. And that's very important in terms of responsiveness. Another promise of arbitration is that it is efficient, it is faster paced than going to court, and therefore more cost effective. So you need to, as an arbitrator, from the arbitrator's perspective, you can't accept a case much as you would like to if you know that your current caseload won't permit you to give the case the time that it's due, both in terms of scheduling and being available. I've got a case right now that is, I'm the sole arbitrator, and it's very contentious discovery. And they've called me up on several discovery disputes, including at the start of a deposition. So you do need to make yourself as available as you possibly can be if you're going to accept a case. Going on to the next thing that you can expect from your arbitrator who's going to accept a case is neutrality. That is of critical importance in your willingness to serve as an arbitrator. So Henry talked about how important it is for advocates to research the arbitrators, right? Because you want to know as much as you can about the arbitrator's reputation, experience, subject matter expertise, perhaps hearing demeanor, anything information you can glean going into an arbitration is of vital importance to your clients. From the arbitrator's perspective, it's very important when you get invited to take a case to review all of the documents, and then you go through a notice of appointment process in the AAA venue, in which you are asked very specific, very detailed questions that are looking to see what interest, if any, you would have in the outcome of the dispute or in the subject matter of the dispute. And what relationship do you have, if any, to the parties, the witnesses, counsel? So we have to go through this long checklist and disclose whether we've heard any cases involving any of the same counsel, anyone from the same law firm, any of the same witnesses. Have they appeared before us? Have we or a member of our family been involved in a dispute with the subject matter? Do we own stock in any of the parties? So it's a pretty thorough process. And if you have a case, AAA has a standard checklist that you need to go through, but there's also a separate one for California, which is even more detailed. So if you have a case that is in California, you are asked even more detailed questions. And it's the best practices I think, for arbitrators to submit a supplemental disclosure. And that I always, in every case I submit a supplemental disclosure, which not only elaborates on any disclosures I may have made in my form checklist, but I also disclose that I've practiced law in Atlanta, Georgia for 36 years now. And so I may have come across or had contacts with people relevant to this case that I don't recall or don't have in my conflicts database and am not aware of, but I promise to disclose those immediately upon becoming aware of those. And also, I talk about in mine social media. So you as the advocates are going to want to be looking to see everything you can find out about the arbitrator. As an arbitrator, I don't participate a lot in social media other than LinkedIn. And so I say, I may be connected with people on LinkedIn that I'm not aware of, and I will certainly disclose it if I become aware of it. I've gotten to a hearing before and had counsel recognize me from walking my child to school. And so he apparently drove his child in carpool line and saw me walking my child. So he recognized my face. That didn't happen until we got to the hearing. At that point, he said, "Oh, I recognize you." So we disclosed that to the other side. At that point, I step out. The administrator takes over of getting the other side's questions. Well, do your kids know each other? Are they friends? Are they in the same class? What's the extent of the conflict? So neutrality is of utmost importance, and we have a continuing duty to disclose anything that comes up that we become aware of. I've gotten to hearing before, and the general counsel of one of the parties recognized me because she was a year behind me in law school. So those kind of things do happen, and you need to have those dealt with as soon as they arise. And the parties have a continuing obligation to update their party checklist so that we know who they're going to call as witnesses and who's going to be their expert and who all their counsel are going to be as soon as possible, so we can be sure that we remain neutral. One other thing I would say about neutrality that's different from the arbitrator, the neutral's perspective, than from the advocate's perspective is unlike you, who should have done a lot of research, see what you can figure out about me, I do not do research on advocates or parties. I personally want to feel as neutral as possible. So I don't want to know what political parties you may have donated to, Henry, or where you sent your kids to school, or what your Facebook profile looks like. So I make it a point in my practice to try to not go in with any preconceived biases. And that's the other important thing for us to talk about and think about from the perspective of the advocate, you can expect your arbitrators to be as neutral as is humanly possible. They've gone through a very thorough conflicts checklist and disclosure process, but we're all humans, and it's very important for us as neutrals to examine our biases. What are our implicit biases, and what can we do to recognize them and hold them in check? And we do need to have a duty, and you need to know you can expect that from us, that when we don't think we can get our biases under control, we shouldn't accept the case. And that's not necessarily a negative bias. Once I was asked to serve as a clerk for a 3 former federal judge arbitrator panel. And judges like to have clerks, and these federal judges wanted to have a panel clerk. And I was asked to take the position. And I saw in doing my conflicts check that the advocate for one of the parties was a former mentor of mine, of whom I thought very highly. And I didn't think I could be completely neutral because I know his work ethic, I know his intelligence, and I thought I would be predisposed to serve, to view through a favorable lens, whatever he advocated. So I regretfully had to decline that appointment.
I'm intervening here using her vision of my screen. A couple of subject matter or situations that have come up that are really interesting in this regard. In the construction arena, people move around all the time. And one of the things the arbitrators generally ask is for a list of witnesses to be sent to the arbitrators, especially ones that are very material witnesses. So the arbitrators will determine whether they've actually represented this person in the past or heard them testify in some previous case. And so, like I said, lots of times they move from one company to another, and it was not an arbitrator, but it was a sole judge making a determination one time where he didn't recognize any of the parties. He didn't recognize any of the subject matters until a summary judgment motion was filed. And he found that the guy that was the principal witness had just replaced the roof on his house. So that would be one situation where, especially within a subject matter realm, sometimes you see the same people over and over again. So when you're an advocate selecting an arbitrator, you've really got to try to find people you think that are very immune to being swayed by outside forces. Another factor that comes up is inevitably you need to communicate with the arbitrators about asking whether they can become the arbitrator for your matter. And we recently had a matter with an arbitration with 6 different lawyers. And we decided to switch up from a 1 arbitrator panel to a 3 arbitration panel, right leading up to the hearing. And so the parties all got together and decided on a list of acceptable people. But then we had to decide, okay, who's going to call these people and check on their availability? Because you could argue that if an arbitrator gets a call from somebody who ask them to whether they can participate in an arbitration, they're going to think favorably of that person because that's their business. So similarly, we had to think about people who are not going to be swayed solely because one of 6 lawyers is designated to make the initial contact so that those arbitrators can be interviewed for the position. I just want to interject there because that's that's almost a litigation tactic that is thrown into the whole process of obtaining an arbitrator, unless you're using a purely hands-off process such as the AAAs. Go ahead.
Yeah, that's a great point, Henry. And I would add that I would say best practice would be for the arbitrator then to disclose in their supplemental disclosure. I have had 1 phone call with lawyer X inquiring as to my availability to serve as an arbitrator. I have not talked to lawyer X since then. So we've talked about neutrality that you can expect from your arbitrator and how you think about it from the advocate and the neutral's position. The other thing you can expect from your arbitrator, and you should demand of your arbitrator, is attention to cost and budget estimates. You know, we've talked about the fact that arbitration is the promise of arbitration is that it's going to be cost effective because time is money and it is a faster proceeding and more efficient. And so there are cost efficiencies as well. However, you do pay the arbitrator or the panels of arbitrator of all three arbitrators. So it's important for arbitrators to have an accurate forecast for you to give to your clients of what this is going to cost. You know, when you select the arbitrators, what the arbitrator's hourly rate is. And you know your idea of what the case duration is going to be and the cost is going to be. The preliminary hearing is the best time to figure out what it's going to take to work out this dispute from beginning to end. I cannot stress to you enough the importance of the preliminary hearing. It's important, and we're going to talk about it, Henry and I, throughout our presentation, the importance of it. One aspect in which it's very important is getting a handle on how long is this case going to take, meaning how many hearing days are we going to have? And we'll talk later about how you schedule considerations in scheduling hearing days, but how many hearing days are we going to have? How complex is this case? How complex are the legal issues? How big are the damages? How many witnesses are there going to be? Is there going to be discovery? Discovery is not guaranteed in arbitration, as you know. That's a big difference between litigation. And so the preliminary hearing is the time that you are going to talk with the arbitrators about what kind of exchange of information, that's the term we use in AAA rules, is necessary. What is the arbitrator going to allow? Does your clause provide for discovery? Discovery is also a huge issue in arbitration. Henry and I are going to touch on it later, and I know that this afternoon a panel is going to touch on it in more depth than we do. So what kind of discovery is involved in this case? How complex is this case? How long is it going to take to exchange information? How long is it going to take to have a merits hearing? How many arbitrators do you have? And motions. There is not a guaranteed motion practice normally in arbitration, of course, unless your dispute clause provides otherwise. And under AAA rules, you have to seek the arbitrator's leave to file an application for a dispositive motion and for other kinds of motions. And you need to show a likelihood of success and that the granting of the motion would narrow the issues in the case. So if this looks like the kind of case that dispositive motions will be requested by one or both parties, the arbitrator needs to take that into consideration as well. After the preliminary hearing, the arbitrator has a much better idea, or the panel has a much better idea of what is going to be entailed to hear this case. Is there going to be e-discovery? What are the various considerations? And how much time is it going to take? And for AAA cases, we're required to submit an estimated budget. And that estimated budget is broken down in terms of what you estimate for potential discovery disputes. How many subpoenas do you think you'll be issuing? What will the briefing parameters be? And briefing is something that you'll discuss in the preliminary hearing as well. And then you are to submit to the AAA your estimated budget, and they give it to the parties. For a panel of 3, we're encouraged to work together. We don't have to submit identical budget estimates because often the chair's budget estimate will be higher, and we'll talk about that in more detail why that is. But we have to give as detailed of an estimate as we can, and we have a continuing duty to update that estimate. So if you get in a case where there are extensive discovery disputes that nobody anticipated, I recently had to do an in-camera review of documents that added a lot more time. Then we have an obligation to update that so that the parties have an idea what they're getting into. And so I would just say, for what you can expect from your arbitrator, and Henry can add his thinking on this too, from the neutral's perspective, you need to expect a commitment to the cost effectiveness of the process.
It's usually you're going to get it from both sides. If you have a sophisticated client, your client's going to be asking you for a budget that's going to include the cost of actually going through the proceeding with the arbitrators that you've selected. And of course, that's something I didn't mention. Arbitrators charge between $225 an hour and $1,000 an hour, let's say. So you obviously, if you have a small budget case, you don't want an arbitrator at $1,000 an hour, because no matter how efficient that arbitrator is, if they're going to give you any attention to your case, it's going to cost a lot of money. But nor do you want a schlock person who is charging way too low and going to give you a crazy outcome. So with respect to budgeting, usually it's a back and forth. You'll get the budget from the AAA by way of them sending you proposed bills. Then you can maybe start thinking about ways, okay, what can we do to cut this down? You're gonna have to go back to your client and say, well, we need to slot in for this many days of hearing, we're gonna have to slot in this amount of cost, both in terms of arbitrator fees and fees to the AAA and hearing rooms. Hearing rooms can become very expensive if you are out of town and having to use a hotel room or something of that nature. But you might look around, you might find a college that can lend you a room, the type of room where they have large sessions of classes, or you might find a law firm that's willing to give up a conference room or a couple of them for a period of time in order for you to have an out of town arbitration. But it all folds into the budget, and as mentioned under some rules, nothing's going to happen until that budget gets paid in large degree. There are certain arbitration forum that if you don't pay the money, essentially the arbitration doesn't move at all. And it certainly doesn't go to a hearing most of the time unless a very large portion of the anticipated fees are paid. And so that's something that's caught private parties in arbitration in a bind a number of times, just because everybody has the budget, but the other side, if they don't pay or can't pay, then you've got to work with your client to decide, well, do we want to go forward with this arbitration or not? And if so, how are we going to pay the other side's fees so that we can get the matter off of square one? Go ahead.
Yeah, and let me tell you from the arbitrator's perspective what we know while you, counsel, are negotiating what to do with a party or parties that have not paid their fees. So on American Arbitration Association, we can see what fees have been deposited. We cannot see and do not know which party has paid or has not paid, but our case manager will let us know prior to the hearing. Not all the fees have been paid in this scheduled hearing. How would you like to proceed, without telling us again who the non-paying party is? And we arbitrators have three options. One, we can proceed. AAA, know that AAA's made all efforts to get the deposits paid, and that the other side or sides are talking about what to do in that event as well. But so we can proceed without all deposits being paid, which is a risk then that we, the arbitrators, won't get paid ultimately. We can delay the proceedings pending all deposits being paid, or we can, and I personally have never done this, terminate the proceedings. So you can just say I've not personally been in a situation where it's gone so far along that I've felt that I could say, we're just not going to hear this case. If you do that, the consequence of that is that the party has to refile. The complaining party has to refile. So there would be costs incurred and time wasted in a new demand. So I personally have never been in an experience where I felt that was the right course, but we do as arbitrators have that power.
That actually sort of leads into the next session of our discussion, which is discipline. I think everybody, if you're going to go out and pay a large sum to hire professionals to run your case, then you would like to have professionals who will actually take the bull by the horns and run the case. And as mentioned, the efficiency is presumed to be one of the desired outcomes of going into arbitration. That's certainly the way it's been sold over the years. And I think it's sort of ebbed and flowed as far as whether people think it's more or less efficient. But we all know that if something lingers on and on, that generally speaking, the cost for the claimants or the respondents goes up. And also justice delayed is justice denied very often. So usually if a matter gets into arbitration and somebody wants it resolved, they didn't file the arbitration for the fun of it, especially if they fought around in court for a period of time before they actually get rolling on the arbitration, as discussed by Valerie. So basically, we'll want arbitrators who, through the preliminary conference, set up a discipline procedure with deadlines, expected final filings, final amendment of pleadings, if at all possible, to frame the issues that are actually going to be decided. Very, very valuable one is an order to require the parties to submit their final damage figures and how they're calculated, perhaps, or at least the outline of the damages sought and the various types of damages, so that it puts the parties in the mode of needing to dig into the case very heavily and to get it prepared. And of course, the rulings and the preliminary rulings, as well as the final rulings, which we'll get to later, need to be clear and unambiguous, so that the parties know they are dealing with people who actually have decided that how they're going to run this arbitration and how they want to see the matter proceed. And of course, for an advocate, that's can be extremely valuable, because sometimes you have a client that wants to delay things, or you have an opposing party you think is going to just skirt everything they can possibly skirt as far as their obligations to the forum. And you want to be, if you're the party that is against the party that's trying to skirt everything, you want to be able to stick it to that other party. And if you're the party that has a client that's doesn't want to comply with deadlines and stuff, you want to be able to use the order of the arbitrators in order to bring your client into line. So clarity of rulings and of decisions is on the preliminary matter is just as important as the ones at the end. You want arbitrators who spend some time crafting a description of what they want within the proceeding, and come up with a reasonable conclusion and can communicate it well. Obviously, you want arbitrators who are self-disciplined and have a willingness to listen to the matters that ultimately are going to be produced in the arbitration, as well as the needs and wants of the parties along the way. Give you an example. We had a matter that was fairly straightforward. It was a arbitration over the installation of a ceiling in a large Catholic church, a cathedral. And I knew that my client did not have a lot of money to deal with a lot of expense associated with arbitration. And so I also knew that I had a witness who was essentially unintelligible from a communication perspective in a formal setting. The person knew everything about putting plaster on the ceiling of a cathedral, but it took extreme discipline to try to understand what the person was attempting to describe orally. So in that instance, I wanted to avoid having deposition discovery. Well, the other side wanted like 3 depositions per side or whatever. And I came in and gave an argument for why this is an arbitration. There was no discovery agreed upon in the arbitration agreement. It's less than $100,000. I'm just pulling a number out of the air. There's no reason for us to be spending 3 days plus all the preparation time times 2 in depositions for this case. And the other side did not know how difficult it was for this witness, who is going to be the critical witness on the interpretation of the plans, how difficult it was for them to express their thoughts. So the arbitrator ruled, okay, we're not going to have any depositions. And that was extremely favorable for me as an advocate, because that allowed me to figure out a way to get the case settled in a reasonable way without ever having to let the other side know how difficult it was going to be for me to present my case. But the same is true with respect to written discovery. Oftentimes, it's not necessary that every custodian's documents for 15 years be pulled off the off the systems of their computers and then processed at extremely high prices for ESI. Maybe it could be exchange of the most critical documents and a ruling by the arbitrator, who says, if you don't produce the document, you don't get to present it at the hearing. And that's your penalty. If you don't give them what you think you're ultimately going to need to the other side, then you're just not going to be able to use it at all. And you better hope that you don't need it for cross-examination or something down the road if you don't give it up. And sometimes you can get to the most important things that way. Of course, sometimes you might miss the most important documents, but that's sort of the risk you take if you're going into a proceeding. But one way or another, you want somebody who lays down clear rules and good deadlines. And those deadlines can be important. So the other thing that you would want is somebody to decide in advance, or at least give a good premonition of what they're going to want from a briefing standpoint. Will there be a pre-hearing brief? If so, how long is it going to be? What should the focus be? And maybe the arbitrator says, I don't want to hear about how an American AIA contract is constructed because I've read 1,000 AIA contracts, that's American Institute of Architects, in my life. What I want to know is how this clause impacts this case, or something very specific as a lead in to the critical issues in the hearing. And then also you want to be able to tell your clients, and you want to know yourself, so for your own scheduling, what is the arbitrator going to want after the hearing, and how long is the process going to be extended out subsequent to the actual presentation of evidence, and when will the evidence actually close? Will the fact evidence close at a certain point in the hearing, and then you're only going to have experts, or are you going to have a normal claimant submits everything hearing, and then respondent submits everything hearing, and then a rebuttal? So there are lots of options that can be pursued by an experienced arbitrator. And what you want from them is to make the rulings, and unless they find they were mistaken or had a very good reason to change their rulings, to sort of stick with their process, so that everybody knows what they're dealing with from a standpoint of getting from beginning to end of the proceeding, which also folds right back into Melinda's budgeting and budget estimation standpoint. Because if something all of a sudden is 3 weeks instead of 2 weeks, that's going to make a huge difference in cost.
Yeah, thank you, Henry. I mean, a lot of the points Henry made underscore again the thesis of the importance of the preliminary hearing. So as an advocate, you should go into the preliminary hearing ready to ask the arbitrator or the panel any questions that you have about what their expectations are. As the arbitrator or panelist, typically panels of arbitrators get together prior to the preliminary hearing to sort of iron out among ourselves how we want to conduct the preliminary hearing and what our various philosophies are, so that you should, by the time you as the advocate get to the preliminary hearing, you should have a prepared panel. So when the panel is all in preliminary hearing, we should end that hearing with the advocates having a very clear understanding of what the process is going to be, because they've had a chance to ask questions, make their arguments, like in the case that Henry talked about with his witness who was not going to be particularly articulate. And you should have an idea of what the process is going to be, with the understanding that arbitration by definition can be more flexible. Arbitrators can be more nimble because the approach is less formal than court, and we do have more discretion. So you can modify the process as you go through, but you should have not if it's going to cause any prejudice for parties who've set up a clear understanding and have a clear understanding of what the procedure is going to be. But if things arise, you can then address them, which is one of the big benefits of arbitration. And it's also a good practice in terms of what to expect from your arbitrator to set up status calls during the preliminary hearing and have those included in the report of the preliminary hearing and the scheduling order, and you can check in. And the best practices for that is to have the parties meet and confer about an agenda and submit a joint proposed agenda to the panel about 2 days prior to this call. And if the parties determine that they don't think there's a need for the call and the arbitrators agree, then the call is canceled. But that's a smart thing to do, to build in from the beginning. So now we've gotten to the hearing, right? We've gotten to the fun part. And what you can expect from your arbitrator is the ability to manage a hearing. That is the crux of the case. And you need to expect your arbitrator to be technologically proficient, intellectually available, and experienced enough to conduct a hearing. One thing we could talk all day about this, I do want to address it though, is hearing format, live versus virtual. Here we are in June of 2022, and we're still talking about this. I think that I speak for all of us when we say we thought that we would have gotten through the virtual hearing phase of the pandemic. We have not. It's still an issue, and you've all had experience with it and been to seminars talking about it and given thought to it. But in terms of what you can expect from your arbitrator, you need to expect that your arbitrator will be COVID conscious, to use Henry's terminology. What are the current COVID conditions? So I've just scheduled an in-person hearing for November, but I've put in my order that we will revisit, in light of whatever the COVID considerations are in November, we will revisit the format. And it may be, we all agree that it may be that we cannot have that hearing in person, but that is the plan at this moment in time. And so live versus virtual hearings considerations, in addition to COVID, council have discussed and discovered what are the benefits now of virtual hearings as opposed to the disadvantages of personal hearings. But one consideration that is, you want your arbitrators to consider ease of scheduling. It's easier to schedule virtual hearings. You don't have, there's cost savings. You don't have travel and hotels. You do need to consider the effectiveness of presentation of evidence, and there are a lot of schools of thought on that. Most arbitrators that I've talked with about it feel that we can evaluate witnesses' credibility in virtual hearings, because sometimes, we're not wearing masks. You can see the witness's face. You don't have the ability to read the room as the advocate, or the arbitrator. And so I've heard more from advocates saying, I really, really want to have a in-person hearing because I think I can present my case more effectively in person. And arbitrators have talked a lot, and we consider a lot how we can evaluate witnesses' credibility in the various hearing formats. But you want an arbitrator who's going to be willing to be open to considering the format of the hearing and changing it if need be. You want to have an arbitrator who is going to give appropriate consideration to scheduling of the hearing. Is it going to be a continuous hearing? Is it going to be held in segments? How long is the hearing going to be? And how long are the hearing days going to be? And Henry alluded earlier to stamina. Is the arbitrator going to be able to pay attention all day long, particularly if it's a virtual format? Are the advocates and witnesses going to be worn down by an 8-9 hour Zoom hearing or in-person hearing? One thing that I think is a big advantage of arbitration is that we can vary the length of the hearing days more than court, right? Because the magistrate judge is going to tell us, I get off the clock at this hour, or the judges, deputies are going to say time to leave the courtroom. I do happen to know the time they cut off the air conditioning at American Arbitration Offices, Association's offices. But if we find that there's a witness that we can finish that day, we can keep going and we can be flexible. We can also vary the order of the witnesses. And it's important to have an arbitrator who will consider varying the hearing times each day within the hearing. So you might be able to start at 9 o'clock on the first day, and to accommodate a witness's schedule, start at 8:30 the next day or 10 o'clock the next day, understanding that maximization of each day's hearing time efficiency of it and effectiveness of it is going to result in a lower overall expense. So you want an arbitrator who's going to keep the hearing running fairly to all concerned, but smoothly and aggressively in terms of maximizing the use of your hearing days, because time is money.
May I interject there for just a second, and that is that an arbitrator can also, and you have, with the expertise that arbitrators have and the overall understanding of the realm in which they're acting, they often can take a witness out of order if need be, and then still sort of pocket in their mind what that witness's testimony was. And that does make a difference if you have people that are doing international travel, or you have somewhat lesser ability to make sure that all witnesses show up at an arbitration by way of subpoena. And so sometimes you just have to take a witness when that person is willing to testify. And that is a huge benefit of arbitration. I'm sorry to interrupt.
No, thank you. That's a great thing to point out. Absolutely. One last thing I would say about scheduling, and then I will go on to presentation of evidence, which Henry teed us up nicely for, is that I think it's a good practice if you can't get agreement from the parties or a clear idea of how many hearing days are going to be needed. Sometimes we'll then schedule an extra hearing day. So hold a hearing from Monday through Friday. Everyone's got that marked down on their calendars, or through half a day Friday, with the hope that we can finish it up by the end close of business Thursday. But everyone, it's good to already have that extra day built in, rather than getting to the end of the hearing and scrambling because you just haven't been able to get all of the evidence in. So let's talk about what you can expect from your arbitrator in terms of presentation of evidence. Remember that the rules of civil procedure and the rules of evidence do not normally apply to an arbitration provision. An arbitration, unless the arbitration clause is a different provision. I've got a case right now that incorporates another state's rules of civil procedure. You need to know that the arbitrator is going to take into consideration all evidence that will further our understanding of the case, that is relevant and material to the case, and give it the weight that we deem it is due. So we're not going to want to waste a lot of arbitration hearing time on hearsay objections. Keep in mind as well that arbitrators are seasoned in sifting through the evidence and deciding how much credibility to give it. Because we sit as both the judge and the jury, we're going to be inclined to hear more evidence, of course, than a judge would take into consideration with the rules of evidence, but also hear it in a different way. So we might agree at the very beginning and remind counsel that you're not going to have to lay as complete a foundation. Documents can be self-identifying to the extent possible. Everything that counsel can do prior to the hearing to maximize the efficiency by agreeing upon certain joint exhibits and agreeing that documents can go in without a foundation, that the foundation's already been accepted as laid, is going to be important. Keep in mind as well that arbitrators, one of the grounds for, Valerie talked this morning, there are 4 statutory grounds in the Federal Arbitration Act, and then in the Georgia Arbitration Code has a 5th. But one of the grounds for vacating an award or modifying an award is when the arbitrators are guilty of misconduct in refusing to hear evidence pertinent or material to the controversy. So that's something that arbitrators are going to tend to hear more and throw out what we think is, worthless or not that credible. However, we're not going to want to hear a lot of duplicative evidence. We're pretty good by this point of having gotten your point. And so we'll let you know when something is looking cumulative or duplicative and ask you to move on. And so you're not going to have to make the point as many times as you would maybe in front of a jury. So keep that in mind as an advocate. Another thing that advocates always are interested in is how are you going to present your documents? Are you going to do it all digitally, technical, or are you going to have paper documents? There are a lot of arbitrators, in the olden days, we all sat around in a arbitration hearing and we all had, banker's boxes full of exhibit notebooks. And there's still plenty of times when exhibit notebooks are valuable. There are also times now when you can do all of the exhibits digitally. And so that's something that you talk about, figure out what your preference is, get a clear understanding of that during the preliminary hearing. You can expect from your arbitrator to be technologically competent. And it's important for arbitrators to be able to use the document sharing platforms, to be able to understand, and we've all figured it out now with during the pandemic, but how to get access to documents, how to highlight documents. So figure out what you think is the best format for presenting your evidence and make sure that your arbitrators are on board with that and have an understanding of that going into the hearing. Then time allocation is very important in arbitration. We've talked about the fact that time is money, and you can expect your arbitrators not to use the potted plant approach and just sit there and let each side take as much time as they want. You're going to have talked in advance about allocation of time. How much time do you think your witness is going to take? Cross-examination of a witness. A good rule of thumb is half a day for a party witness or an expert witness for direct, and half a day for cross. Think about that when you're building in hearing days. And know that your arbitrators may want to use a chess clock approach. If they sense that there are multiple parties, or the parties are going to have a hard time sticking to their time limits, then arbitrators can use a very strict system with the chess clock approach. That is something you need to let parties know, obviously, before you do that. And the last thing I would just say in terms of managing a hearing, because I think we need to move on, is that you can expect from your arbitrators a respectful demeanor, a poker face. You don't want arbitrators who are going to be dismissive of your arguments or dismissive of your representative. One thing that's important to learn, and young arbitrators learn it pretty quickly, is again, back to the question of biases. You don't want to ever, as an arbitrator, give too much credence or too little credence because you don't have an affinity for the counsel, or the party witness is a hostile or an abrasive witness. You have to work really hard to overlook that and get to the merits. And I think as advocates, you can expect that from your arbitrators. You don't want visible reactions, except you, of course, are trying to get clues from the arbitrators, from the questions that we ask or any interim rulings. But in general, we arbitrators want to have as much of a poker face as we possibly can.
So we have a lot to cover in a very limited period of time. A couple of just quick comments on speed and efficiency, what to expect for the arbitrator. One thing that I found that's never good is a arbitrator that sort of waves off a issue presented by the parties and issues some sort of mealy-mouthed ruling. I think that advocates can expect to ask their arbitrators, I want an answer. Do they have to produce the document or not? If you're going to have a hearing on the subject matter, as opposed to, y'all come back to me in a week and let me know what you think, or something like that, because we need to move on with a matter. And if the matter's been clearly presented to the arbitrator, then strict and important rulings need to be made firmly. We were going to comment briefly on the award and drafting of the award, and I'll start that off, and Melinda will take it from there. But essentially, you need to ask your arbitrator what kind of award you want. Remember, a thoroughly well-reasoned finding of fact and conclusions of law is expensive, but if you're going to need that to explain whatever outcome there may be to your client, definitely ask for that. And also, if you're going to be able to not sleep at night at all, if you just get an award that's against you and you have no idea why, you might ask for a well-reasoned award. Melinda, maybe you can take this last brief segment.
Yeah, let me just say briefly that it's important for arbitrators. We want our award to have addressed every single issue. At American Arbitration Association, we have a checklist, an award checklist. We have to make sure we've addressed every claim, every issue. It's very rare that I have parties say that they want a non-reasoned award. I mean, that's just the basis these days. Everybody wants to know. The question is it going to be, it's also very rare that they want one as detailed as findings of facts and conclusions of law, but you do want to give as an arbitrator enough reasons that that the parties can understand why you decided what you did. There's a criticism of arbitrators that we tend to split the baby. I don't know that that's I think that's more a reputation than in reality, in my experience. But you certainly don't want to just come in and say, oh, well, let's just half it down the middle. In terms of panel dynamics, I will tell you that a panel, you want to give an opinion that's unanimous, a decision, an award that's unanimous, but that's not required. You can, a 2-arbitrator signed decision is as valid and enforceable as a unanimous one. And I want to make one last point about enforceability of arbitration awards. I told you earlier that there's 4 grounds under the FAA, and Georgia has added a 5th. Georgia is unique in that, and it's called manifest disregard of the law. A lot of arbitrators tend to take personal offense at that because we say, well, we're not going to completely disregard the law anyway. And there's a little bit of an overlay in federal courts to the 4 statutory grounds for the FAA anyway, which is if an award is arbitrary and capricious or contrary to public policy. So many arbitrators feel that that's not a necessary 5th ground, but you should know that you certainly can expect your arbitrator not to manifestly disregard the law. That's like the floor, right?
Well, thank you both very, very much. We are through our hour, and clearly we could invite you back next year when we do this again to talk about this, because you have such a wealth of knowledge. And so I'm very, very grateful to you and for your time. And so now at this point, Judge Tucson, if you put on your video, we are ready to transition. We've got Judge Gail S. Tucson to talk to us about a young attorney's guide to successful arbitrations. Judge Tucson is a senior judge in the Fulton County Superior Court. She has more than 30 years of judicial service. She's joined JAMS, and she is an arbitrator and mediator with JAMS. She has great experience for working with young lawyers, mentoring others, and using ADR processes to come to a resolution. And we're very excited to have you with us, Judge Tucson. Thank you for being here.
Thank you, Erica. I'm happy to be here, and I hope everyone can hear me clearly. I have been on with video off for most of the morning, and am thrilled with the wealth of information that has been shared during today's program. I was asked, however, to focus more on the basics from the perspective of a newer or a young attorney maybe doing his or her first or second arbitration, having presided over several arbitrations. And, it is not unusual to see a younger attorney accompanying the attorney that is in charge of the presentation. And you can absorb a lot, but it's also helpful, to have your own playbook as to how to get a successful outcome for your client. I made the transition from the bench to JAMS about 3 years ago, and have really enjoyed the opportunity to help resolve disputes as a neutral. There are definitely differences between preparing for a trial as well as preparing for an arbitration. And I think as we go through my segment, I'm hoping to make some of those distinctions apparent for practitioners, and certainly will welcome along the way any questions that anyone that is attending may have. Hopefully also to give you, a few checklists and tools for you to make note of, and we can follow up even after the presentation if you would like me to send you anything directly. One of the differences, I think, between dealing with an arbitrator versus a trial judge is that you don't have the normal buffers that you would have if you were presenting and preparing a case for trial. You're dealing directly with the decision maker almost always, whether it's a conference call or a hearing, virtual or in person. And the arbitrator doesn't have the typical staff that a trial judge would have in helping her to resolve your case or controversy. In addition, even though the goal, of course, is to have a big, busy and active arbitration practice, most likely your arbitrator is going to have fewer cases than an appointed or an elected trial judge would have on a docket. And that's a good thing because that gives you more access to your decision maker and more opportunity to probably make a good impression on him or her in trying to resolve your case. You also, as we've heard, Melinda and Henry pointed this out, in many instances will have more flexibility in preparing and presenting your case than perhaps you would in traditional litigation. And so that's also a good thing. So there are a few things that, of course, should be kept in mind. There has been lots of discussion about the arbitration agreement. From my perspective, it's really important for you to actually not read not just the gist of the subject matter of the contract that contains the arbitration clause, but what does it actually say and permit? Because that will govern the scope of your hearing, what issues can be brought, what issues are not subject to arbitration, and of course, which parties are properly before the arbitrator in making a decision. If you have any concern about any threshold issues, the arbitrability of the dispute, what law applies, any of that, by all means, those would be considered important threshold issues that you should bring up sooner than later. Typically, when I receive an arbitration assignment, I am forwarded the demand for the arbitration. So that is the first pleading, if you will, that I would be reviewing, that the arbitrator would be familiar with to understand what the arbitration is about. And it is, it's not always the case that the respondent has actually filed an official response to the demand. And so make a note for sure that it is important that there be a responsive pleading so that the arbitrator has a full understanding of what the issues are, why there is a need for an arbitration, as well as what any responsive defenses, anything that would be raised in response that might pertain to the actual arbitration. There has been a good bit of discussion about, knowing your arbitrator, getting an arbitrator that is really going to have hands-on and manage the arbitration. That is so very important. And most arbitrators are going to have a preliminary scheduling conference that is set up early in the process so that you do have deadlines so that you understand the arbitrator's expectations and can do your best to meet them, as well as I said earlier, raising any issues or questions that you might have. Typically at JAMS, we will send out to the parties a preliminary conference checklist. And it's pretty thorough. I'd like to go over a little of it with you at this time so that you'll know the types of questions that are very important in setting the stage. Now, that being said, of course, the object of an arbitration is to be efficient And we certainly want to require the parties to be reasonable in their conduct, and therefore deadlines are going to be very important. But on this checklist, some of the things that the arbitrator is going to want to be sure is that there are no questions with your selection of the arbitrator and his or her qualifications. You're going to want to discuss where is the arbitration going to occur. Once again, going back to the arbitration agreement, it usually says where the arbitration is anticipated to occur, whether that is in, the state where the contract was formed, where it was performed, where the parties reside. Oftentimes, if you have consumers or employees on one side of the arbitration, the clause will provide that the arbitration should take place in the locale of that individual. Again, trying to make the process accessible and fair. There will be discussion question at this preliminary conference as to which law governs the arbitration. You may have particular rules. If you're proceeding with JAMS, you will have JAM rules. You'll have AAA rules, and then you'll have federal or state substantive rules that are going to govern the proceeding. And so it's important to be clear sooner than later as to which laws do apply, and if there are any issues as to conflicts of the law, to get that hammered out sooner than later. With respect to your discovery and your document disclosures, are there any protective orders that are going to be needed? Are there any other orders that are going to govern electronic review, et cetera? Those are things that you need to be prepared for on behalf of your client. And ideally, you would actually reach out to the other side and have a preliminary discussion and submit your responses to these questions in advance. That will expedite the conference and will give the arbitrator information that's valuable for purposes of preparing. Are there going to be expert witnesses? How many witnesses do you anticipate, and where are those witnesses located? I believe that there was some mention earlier about the hearing days. So this definitely is important for purposes of your scheduling. And if you're not positive as to the length of the arbitration, then you want to go ahead and reserve the minimal time that you think that you're going to need, and perhaps alert the arbitrator that there may be a need for an additional day or more to make sure that he or she is aware of that, so that it can be scheduled and your arbitration hearing doesn't end up getting split up into non-consecutive days, because that obviously is not desirable from the perspective of the parties in preparing and not wanting to have to repeat the preparation. Likewise, for purposes of the decision that the arbitrator needs to make, it is ideal for the hearing, if at all possible, to be scheduled on consecutive days. Other questions that you might ask of the arbitrator at this time is, what is the preference for raising issues? Is it email? Many of us are using internal messaging and case management systems that allow more expedited communications than the normal email. But whatever is being used, it's good to understand this from the outset, and other issues such as that. One thing that I think is important and can come up just as frequently, if not more, as it would in a trial that's going forward, is that your adversary may not be an attorney. Most rules provide for parties to be represented by counsel, but that's not a requirement. The party can be self-represented, or the party may have someone else who is not an attorney assisting them in their preparation and perhaps a presentation. So you're going to want to have a good discussion with the arbitrator about how the process should proceed when everyone is not a member of the bar. And that process with your self-represented litigant is going to impact how the arbitrator responds to questions. It is really important for everyone to understand what the rules are and to be comfortable with the process. And I have had lots of cases with pro se parties where even though a lot of time and care has been given to making sure that everything is explained, it still isn't clear even as of the day of the final hearing. And so there may be a need, perhaps begrudgingly, but still a need for you as the attorney on one side, to extend the courtesies that would be necessary for purposes of the overall objective of the hearing being efficient. So you might need to screen share for the pro se party if all of the documents are convenient and housed in one spot. You probably are going to need to explain the procedure and be more patient than you would necessarily need to be with someone who knows all the rules, because they're anxious and they simply want to get their point across. And in many instances, this is the only opportunity that they're going to have to get their case resolved. I'd like to talk a little bit about your written submissions and making sure that each step along the way you use your submissions to educate and to persuade appropriately the arbitrator. Of course, less is usually best, but it is important to be detailed in terms of your relief, in terms of that you're seeking the authority that you're asking or submitting on behalf of your relief, as well as details as to how the arbitrator is expected to resolve your case and perhaps issue an award. As mentioned earlier, most arbitrators don't have staffs such as we would have had in Superior Court. So we don't have staff attorneys available necessarily unless it has been discussed and that additional expense has been agreed to by the parties to review pleadings, to research, to help draft, that sort of thing. And so for that reason, I just urge you as you're beginning your arbitration practice to develop, I guess, the discipline and the practices that are going to help the arbitrator help you in getting your case resolved. Dispositive motions are not encouraged, especially under any streamlined rules, or when you're again dealing with consumers, employees on one side that may not be represented. Dispositive motions, of course, can be very helpful if it is clear as a matter of law that the arbitration should not proceed. But would urge you to resist the time and the expense of preparing something that would be comparable to a motion for summary judgment if in fact there are disputed facts that will just need to be better fleshed out at a final hearing. Some of the rules, our rules in particular, typically require you to actually ask leave to file a dispositive motion as opposed to you're going ahead and just submitting it. So make sure that you're clear on the rules that govern your arbitration on nuances such as that. In terms of submissions that I find helpful, I do favor and typically, especially in cases where there are arbitrations for individuals, but a lot of similar cases and the attorneys are used to working with each other, they'll ask to just go ahead and submit a proposed joint discovery plan. Of course, it's going to be reviewed. It's not necessarily a given that it will be granted, but it usually would be if it's reasonable and time efficient. That's very helpful. Prior to an actual final hearing, I have found it very helpful to have pre-arbitration hearings statements submitted that set forth, once again, what your claims are, what your authority is, and the specifics of the relief that you are seeking. It has been helpful as well when the actual hearing begins to maybe have a hard copy or an electronic copy of an opening statement outline, whether that's a PowerPoint or some other document that has been prepared that is available to the arbitrator to refer to throughout your hearing. And then typically there's also discussion of this even at the preliminary hearing, but certainly by the time you have your final status conference before a hearing, the final hearing, as to whether or not the arbitrator would prefer to hear oral arguments at the time of the conclusion of the evidence, or a post-hearing brief, or perhaps both. It saves time on the one end if you're close to the end of the day and everyone is fatigued, so to make sure that you don't leave anything out of your closing, to have an opportunity to review the transcript and submit your post-hearing briefs in writing. But not everyone wishes to do that, and that's just something that typically is discussed with the arbitrator. So as already stated, of course, your rules are going to govern, and it is important for you to know what they provide for, to make sure that you don't just kind of jump in and assume that you're going to have the type of discovery that you would have in a case filed in state or federal court governed by the Federal Rules of Civil Procedure. Documents typically should be shared early in the process. It is not helpful, to kind of play the hide and seek game with the documents. It is just for everyone's purposes better to go ahead and share the relevant documents, since everyone really knows what they are. And by all means, to try to be consistent in how you refer to the documents throughout the arbitration. Typically, I think the inclination by arbitrators is to try to keep discovery under control and to keep it from running up everyone's costs and extending the time prior to the final hearing. Everyone understands that basic discovery is essential to a fair hearing. That's not what I'm saying, but in terms of the number of interrogatories or the requests for production of documents, less again is best. The typical kind of boilerplate objections that younger lawyers learn how to submit, those really get us off on the wrong foot. I can't count the number of conferences that I have had where we ultimately have ended up identifying what is the necessary information that, in fact, despite the objections, everything is going to be or has been produced. And it just, as I say, kind of gets things off track to have to work through the boilerplate objections that we have all seen. Likewise, depositions. The norm isn't to have several depositions all over the place for unlimited periods of time in terms of hours and days, but rather to focus on who your key witnesses are, and in that regard, with those depositions, to access the arbitrator as needed if there are any questions, but to understand ahead of time kind of what the game plan is going to be for them. So in terms of the final hearing, this is typically occurs after you have scheduled at least one final conference, and you should not be hesitant to ask for the conference if for some reason it is not already one of the events that everyone is contemplating occurring. There usually are questions that may range from the substance of the hearing to the actual logistics of the process. I have found that it is helpful, if possible, to really have one set of final hearing exhibits, so we're not all flipping back and forth between two sets of notebooks or different digital files. The exhibits obviously should be marked and shared in advance. How you share the exhibits can depend. I have had the experience of parties using document share companies who do all of this for them. If it's not as complicated of a case, then usually attorneys, paralegals, office staff assist in sharing the documents. But it is important for everyone to be comfortable with the process. And going back to my earlier point about pro se litigants, they probably will have organized the documents in their own way, may be somewhat distrustful of using your exhibits, and they want their own copy, even if they're duplicative. And so you roll with that as you need to, so that everyone feels comfortable in making their presentation. One question that sometimes comes up is whether or not if we're going to use a chess clock, or how the time is going to be allocated. It is very distracting for the arbitrator herself, to be the person trying to keep track of time. Usually both sides are very precise in how much time has been used each step along the way. I have found it to be more helpful to ask, and usually they don't mind, the court reporter to actually keep track of the time. But if you have, 2 to 3 days, whatever it is, or longer for your hearing, you do want to make sure that you have an equal amount of time, sufficient time to present your case. So don't hesitate to raise that question and to make any suggestions based on what has worked well for you in the past. In terms of witness testimony, we've already talked about or heard in a previous segment about the flexibility of witnesses depending on schedules. The arbitrator is more than capable in taking witnesses out of turn as necessary, just to make sure that things keep moving. There's nothing worse than coming to a crashing halt because someone isn't available. Because of the flexibility that is afforded by the virtual platform, it is commonplace now, to have witnesses testifying virtually, even if attorneys and the arbitrator and the parties are all present in person. Make sure, though, counsel, that you prepare your witnesses for actually testifying virtually so that they will know what technology they need, so that they have focused even on things like, what's in the background. So there have been instances where I have been a little surprised at the backgrounds for some of the witnesses. I recall one case where, she was up and live and she was in a room full of moose heads, and it was somewhat distracting, but you do your best to keep that poker face and to focus on what the witness is testifying to. We have had some problems with the audio when we're in a hybrid hearing format. So make sure that all of that has been tested in advance. And by all means, if it is a hybrid or virtual hearing, whichever service you're using for company you're using rather for your arbitration, they should be able to help you and provide the technology training necessary for your witnesses to be able to be effective. As to experts, you may make a note that in arbitrations, sometimes it is most effective to actually use a technique referred to as hot tubbing, where the experts are present for each other's testimony without question, and also kind of testify and ask each other questions as opposed to being examined by the parties. And that has been particularly helpful, and I think is, pretty commonplace in arbitrations where there are experts. So check into that if you have not been exposed to that particular process. In terms of kind of the flow of the day, I would say for the hearing, it's important to the arbitrator, I believe, always to kind of set the stage and get started on time, to take the necessary breaks so that no one is fatigued. But as you are kind of counting on the time that has been afforded for the hearing, don't assume, I guess, that people, the court reporter, the arbitrator, or even yourself, that you can just kind of go nonstop and or with minimal breaks, because clearly, your attention, your concentration, your preparation, all of it will be more effective earlier in the day. And so extending days into the evening is not necessarily the best practice for purposes of a hearing that will be multiple days long. Now, if you're trying to get a witness in or there's a plane to catch, then we all do what we need to do. But to do that consistently, it's my practice or experience rather than, trying to go beyond eight hours in a day after day, can be very tiresome for everyone. I think I've already mentioned the post-hearing submissions, but just to make sure, after the hearing, when it comes time for preparing what we have discussed as being a reasoned award, typically if the parties have engaged a court reporter, we give the court reporter an opportunity to prepare the transcript. That's helpful for everyone. We gather all of the exhibits, and I encourage if parties are able to submit post-hearing submissions, that's a helpful way to kind of summarize the case from each side's perspective, and gives me as the arbitrator an opportunity to kind of compare that to my notes to the transcript. So that's all very, very helpful.
Judge Tucson, we had a question before you left the slide. I wanted to jump in on time division.
Yes.
So a lot of times, and I think this may surprise younger advocates in arbitration, is the amount of questions that the arbitrator may come up with, right? Sometimes there are no questions at all, but sometimes there are arbitrator questions. Do you allocate that in the time division, or do you just, how do you handle it?
So that's a great question. And as someone who does ask a lot of questions, thank you for that. I think what's fairest is to go off the clock, while I'm asking the question, because I believe that, if I'm taking the presentation, perhaps in a different direction than was intended, or if I'm expanding it, I don't think it's reasonable for that to come off the advocate's time. So I would say, stop the clock generally, get the question answered, and then go back on the clock.
That makes sense. And then the next question is, do you, we were talking about witness testimony, do you require the parties early on to share who's going to come, when they're going to come, what order they're going to present folks? How do you normally handle that?
Yes, I don't like surprises at this arbitration. And so the preliminary checklist will end up with a scheduling order, if I didn't actually say that. So as a result of the conference, all of these questions, there will be a scheduling order. And so the scheduling order will require parties to identify who their witnesses are going to be by a certain date. From what I am remembering, most times it's, probably within 6 to 8 weeks before the actual final hearing. And then once we're there, then I do think generally there is a sense of, if you tell me, I'll tell you. And so we kind of indicate, well, who's up today, kind of what is the order, and kind of go from day to day.
Thank you so much.
Thank you. I wanted to talk a little bit about attorney's fees, because that is usually also covered in the clause that provides for the arbitration. And so you need to be, reread that and make sure that you are clear as to what provision there is for this request. So the arbitrator needs to be briefed on the legal basis for the request, what the authority is. And then there's a good bit of time spent on this issue, especially if the provision indicates that a party who prevails, blank, 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 can recover, whether or not the client actually prevailed. And, there's a lot of case authority out there on this issue. But typically, if the agreement says that if one prevails on a particular issue, the party can seek fees, then even if the party didn't prevail on everything that the party perhaps requested, if in fact the party prevailed, then that party is entitled to request attorney's fees. And so then you have an issue of, making sure that you have provided the arbitrator with the necessary documentation so that the arbitrator can determine whether or not the fees were necessary and reasonable. And I have had instances where the documentation, you get the standard affidavit, what the experience is of the attorney and the rest of the timekeepers, and what the prevailing rate is in the locale where the services were rendered. But then there's this issue of, well, what did you actually do, and how to allocate the fees to the prevailing claims. And so that takes a little bit of time and study, and the redaction block billing, those two particular circumstances make it more difficult for the arbitrator to ultimately determine the necessity and reasonableness of the fees. So one, if you have concern or want to redact your invoices, you need to make sure that you haven't redacted so much that it's really just a matter of numbers and the arbitrator isn't really in a position to assess reasonableness or necessity. In that instance, you might offer an in-camera inspection if there's no way to get around the redactions. Likewise, with block billing, you want to have enough specificity such that the arbitrator can determine who did what and how did it relate to what the arbitrator has determined to be the prevailing claims. So the other thing that I will share is that depending on the firm that you're practicing with, it may be the firm's policy, to bring in certain attorneys with certain expertise at certain levels for certain issues, and you have a constant timekeeper throughout the process. But the arbitrator is going to want to feel like the attorney's fees have some proportional reasonableness, I would say, to what the ultimate recovery is. And so you may need to consider yourself before the arbitrator steps in to decide what you may want to back off of your request. So it's not necessarily that it wasn't necessary and reasonable from the perspective of your firm to have assigned whoever has been assigned. But if you have several timekeepers doing many different things, as well as usually the supervising partner and the senior associate, you just need to keep all of that in mind and do your best to present as an objective request as possible. Were there any other questions, Erica? Sounds like not. We mentioned earlier the issue of a court reporter. Because, of course, the goal is to keep arbitrations as cost-effective as possible, that's a question that has to be decided, and as well as deciding who's going to have access to the record if one is created. So it is obviously extremely helpful in a very detailed case to have access to a transcript, but it typically hasn't been my case when the court reporter has been engaged for the court reporter to necessarily be providing real time to the arbitrator during the actual hearing. It's more something to refer to afterwards. So give that some thought in terms of what your client is capable, can afford, but also have some discussion, I would suggest, with the arbitrator to make sure that the arbitrator doesn't have any views that you want to take into account on the helpfulness of having a transcript. Proposed orders, probably common sense, but trying to submit them within a short time frame, as opposed to, taking 20, 30 days, as we may all be accustomed to, will keep the arbitrator engaged and keep the process moving. We mentioned earlier, making sure that the arbitrator is helpful in making actual decisions. I absolutely agree with that. That is our job. Whatever you need us to do, you should simply ask. But if you are offering, to present a proposed order. Again, I think it's more helpful to have it closer to time of the hearing or the conference than later.
Judge Tucson, this is Erica.
yes.
I just wanted to make one point for you, court reporter in Georgia. So if you find yourself in the Georgia court on a motion to confirm or a motion to vacate, not that that would ever happen to you, Judge Tucson, you have to have the transcript. The court won't look at a petition to vacate an arbitration award or modify an arbitration award if you don't have a transcript. So very important. A lot of people go to arbitration without a court reporter, and I think that's a dangerous practice.
Okay, good practice tip. Thank you, Erica. I noted earlier, or it might have been in one of the checklists, I apologize, I don't recall, but in terms of the actual award, the practice of requiring parties to, kind of outline specifically what they're seeking, numbers, calculations, as opposed to just the type of generic relief, is extremely helpful and highly advised. You should not be shy to do that. You may even offer to do that. In the end, I think it will behoove everyone that is representing a party in an arbitration to have that specificity. Again, probably goes without saying, often proposed orders, et cetera, are submitted only as a PDF. And if it is going to be used in any way, it is more difficult if it's in a PDF only format. So just keep that in mind. Maybe you can submit it as a PDF initially, or follow up with a Word document so that it can be more easily used by the arbitrator. So this may be good for those that have been sitting since 9:30, but I actually, that's what I had prepared. I'm happy to answer any questions.
Sure. So this is Erica. So yeah, you can put the questions in the Q&A and I can forward them to Judge Tucson or ask them for you. But Judge Tucson, I had a couple of questions when it comes to witness preparation for particularly for young lawyers in presenting your witness. Do you have any tips about making sure that the presentation of the evidence is helpful, seamless? Any sort of thoughts or tips you can give to our younger litigators?
One thing definitely comes to mind, and I'm thinking of a case in particular where, especially if it's the party, they know kind of what they want. They know what their story is, what they want to share. And oftentimes they're impatient, I guess would be the best way to describe it, in with the process and understanding that the attorney has prepared, knows the case, is going to get everything out, but they talk longer than they need to. They go way beyond the answer that was intended by adding on everything else that they think to know, and then they're trying to anticipate the next question. So I guess the advice would be to try to emphasize to your clients that it's not that you don't respect their perspectives, but that you've listened and you've prepared and they've had their opportunity to talk directly to you or your team. But at this point, when you get to the hearing, they really need to trust you as the advocate to know the best way to present the case, and that there is an order, an intentional order, and that there will be an opportunity, for you to ask them if there's anything else, when you're finished, but to kind of let you go through your order of proof as you have prepared.
Great, thank you. Do we have any other questions? One here, hang on. Well, I think that's all we have. So if I give a couple folks really quick time to punch in a question, but otherwise I think we are good for the day. And I do know people appreciate getting up and stretching. On Zoom is one of those things that we don't know if they get up. But Judge Tucson, thank you so much for joining us today. Thank you so much for sharing your knowledge and wisdom and insight. Really greatly appreciate it. We will be done for the morning session. For those of you who signed on for the afternoon session, we'll start at 1:30. I will say that we have been experiencing some Zoom issues with folks getting kicked out and back on. We apologize for that, but it's unfortunately beyond our control. So thank you so much everyone for being here, and I hope we'll see